This is Bloomberg Law with June Grasso from Bloomberg Radio.
In a high-profile clash over presidential power, a sharply divided Supreme Court allowed President Donald Trump to resume deporting alleged Venezuelan gang members under an 18th century wartime law. By a 5-4 vote, the justices tossed out a lower court order that had paused deportations under the Alien Enemies Act, but ruled that detainees must have notice and a chance to make their case to a judge before being deported. The court was bitterly divided, with the majority downplaying the significance of the decision, and the minority, the three liberal justices and conservative Justice Amy Coney Barrett, complaining that the court was rewarding the government for conduct that posed an extraordinary threat to the rule of law. My guest is Leon Fresco, a partner at Holland Knight, and the former head of the Office of Immigration Litigation in the Obama administration. Leon, let's get straight what the court did and didn't rule. So the justices cleared the way for the government to continue using the Alien Enemies Act to deport alleged Venezuelan gang members, but they didn't rule on the core question of whether it was lawful for Trump to use the act in this way.
In the end, this was a very narrow ruling that really came down to whether the district court in the District of Columbia was the correct forum for challenges of the use of the Alien Enemies Act. And what the Supreme Court said in a 5-4 decision was that if someone wanted to challenge their detention and or removal under the Alien Enemies Act, they had to do it in a habeas corpus claim, not an Administrative Procedures Act claim, and that the habeas corpus claim needed to be filed in the location of the detention facility where they were held. So what had happened was, when the president had signed the order invoking the Alien Enemies Act, these individuals were in the middle of being transferred, and it wasn't clear what kind of law applied in this situation. There was some bad case law from 2020 where Justice Alito had written that you couldn't use habeas to challenge removal orders, and so it wasn't clear who could do what. And so the lawyers for the individuals that were detained under this Alien Enemies Act proclamation filed a lawsuit under the Administrative Procedures Act challenging what was a proclamation. So that was an administrative procedure in the District Court of Columbia, and that is where there was this oral injunction not to deport people, and then that oral order turned into a written order, but by the time it was, the planes had already landed in El Salvador. And the case continued up to the Supreme Court, but now the Supreme Court said that lawsuit in D.C. under the Administrative Procedures Act was incorrect, and instead what needed to happen was there needed to be a habeas corpus claim. So the good news in terms of where we're at in this decision is there isn't really yet any interpretation one way or the other about anything substantive related to this act. There's just a decision that lawsuit needs to take place at the moment where they're held, which is the Southern District of Texas, which is in South Texas. Now, the other thing that's very interesting is all 9 justices, even though it was a 5-4 decision, agreed that the Alien Enemies Act was something that could be challenged in court, meaning that a person who is detained and that the government wants to deport under the Alien Enemies Act can ask for review on all of the following issues. Number one, was the act properly invoked? Second, was the act properly invoked as to this individual? And third, does this individual have other defenses, even if it was properly invoked, in order to avoid deportation? All of those things can be challenged, according to the Supreme Court, under a writ of habeas corpus, which was the original way people used to challenge their deportations for over 100 years. But that had been foreclosed in 2022. The court had reopened it as a venue for challenging a deportation in this context of the Alien Enemies Act. So now at least there is some comfort, I guess I would say, that there aren't people in the United States who can be just detained and deported without any due process, which was an argument that was being made, and now that is not the case. Now, all 9 justices in the Supreme Court have said otherwise.
So the justices might have agreed on the fact that the detainees should get notice and a review before being deported, but there was a sharply worded and fervent dissent. Justice Sotomayor said the court's decision to rule now is as inexplicable as it's dangerous. She warned of life and death consequences, complained that the court was creating new law on the emergency docket. So while the majority tried to make it, oh, this isn't about much, we all agreed on this, the dissent is furious.
Well, the concern, I think, is of the following nature. Even after this decision was issued by the Supreme Court that basically said this is just about whether it's about a habeas case or about an Administrative Procedure Act case, and whether it should be filed in D.C. or whether it should be filed in the district where people are being detained. So that was it. That was the only thing that was decided in this case. Because theoretically or technically, the order from the district court judge in D.C. was vacated because the D.C. court no longer was the right forum. The forum needs to be in South Texas. You already had tweets coming from the administration saying that the judge has been overruled and deportations will immediately begin again to El Salvador of Venezuelan people. And so that was the concern Justice Sotomayor was voicing, was how is this court to guarantee that more people won't now be deported during this very short interim process where people are supposed to now challenge their deportation in the Southern District of Texas, because now those people have to file another complaint and they need to go through it. And yes, it's true the Supreme Court says they have to have an opportunity to do it, but they don't say how many days, what is the opportunity, etc. And so maybe the United States government takes the position that, well, if you didn't file it within 15 minutes of the Supreme Court decision, then you've lost the opportunity and the notice to do this, and we can start deporting people again. I don't know how much leeway the administration is going to take with regard to what is an adequate amount of notice. But in any case, that was the concern that Justice Sotomayor was voicing there. And she did try to say, in order to try to, prevent such a scenario, and this was a sentence that even Justice Coney Barrett actually signed on to, because she signed on to parts of the decision and not others. She said, and this is a very notable sentence, to the extent the government removes even one individual without affording him notice and a meaningful opportunity to file and pursue habeas relief, it does so in direct contravention of an edict by the United States Supreme Court. So she's trying to say, don't dare do this. But in the end, there was no time frame given about what is adequate notice and a meaningful opportunity here. And so this is why she used such scathing language. And then finally, she was saying, why have we decided in a matter of hours that you don't have Administrative Procedure Act relief in a case like this, and that habeas is the only thing that's necessary, when this is such a complicated legal question? Normally, we would let the lower courts weigh in and then let other appellate courts weigh in, and then we'd have the benefit of all of this analysis to make such a decision. Here we're just making this up on the fly in one of the most important constitutional contexts possible. So that was her other criticism of what the majority did there.
I mean, the reason the Trump administration used the Alien Enemies Act is because they wanted to deport people quickly without any process. So in that sense, if they follow what the Supreme Court says, it's a loss for them because now you have process involved.
Correct. This will now make it longer, although it's not as long as an actual immigration court proceeding where you have to go to the immigration court and the Board of Immigration Appeals and then potentially a petition for review in the Circuit Court of Appeals. It won't be that long. It nevertheless will have some procedure involved in it. Unclear how many days a person will be given to file a habeas who's detained under this proclamation, but it is clear they have to be given some amount of time. And then the question is, when they file this habeas, well, how long is a district court going to take in order to make a decision in a particular case? Is this a trial? What actually happens here? How does someone prove they're in this gang or not in this gang? All of that will need to be worked out. And so depending, this could still be a very short process, or this could be a process just like any other federal litigation that could take over a year or 2 years to resolve. And I think that all still needs to be fleshed out and worked through in these various lawsuits that are now going to happen in the Southern District of Texas or maybe in other locations.
Let's look in the future. So a Venezuelan is given notice by the government, we're going to deport you to El Salvador. That person has to get a lawyer right away to file a habeas corpus petition.
Correct. Presumably, the way that this would work in pretty much every context is you would get this notice after you've been detained by ICE. It seems very unlikely that if you were, quote-unquote, an alien enemy, they would just let you walk around in public. So what would happen is ICE would come get you, pick you up somewhere, put you in detention, give you this notice, and then once you got this notice, you'd have whatever amount of days that it's in that notice to find yourself an attorney and file a habeas, because if you don't, then you could theoretically be deported to El Salvador under this proclamation. Now, perhaps one day there will be a writ large injunction that prevents the use of the Alien Enemies Act in this context, but until that kind of injunction is imposed, yes, on an individual by individual basis, people will have to file these habeas lawsuits in federal court, either by themselves or with an attorney, before the removal can be accomplished. And then the question is, well, okay, what does filing that claim mean? Does that mean there's an automatic stay, or do you actually have to get a stay of removal issued by the court as part of this habeas? And if you actually have to get a stay, that's a much more difficult burden, because there you have to show you have a likelihood of success than just filing the complaint, and that becomes an automatic stay. And so all of these things are going to have to be worked out. And so it could easily be foreseen that the government might take the position, well, if a court hasn't stayed your removal, it doesn't matter that you filed it. You actually have to get a stay in order to get it removed. And so the question is going to be, how aggressive is the government going to be in trying to find ambiguities and loopholes in order to keep deporting people into El Salvador? Or are they going to play this more conservatively and just wait until they actually have an order that permits a removal under the Alien Enemies Act?
And this also means that the government can basically choose the jurisdiction that the habeas corpus proceeding is going to be heard in, because they decide where to hold the detainees. And, for example, the courts in Texas are not usually as friendly to these kind of immigration claims than the courts perhaps in D.C. or Manhattan.
2 points there. One, this is theoretically true unless basically every Venezuelan decides to have a pre-written habeas petition ready to go that can be filed within seconds of their apprehension in the jurisdiction they live in. Then theoretically that place would have jurisdiction over the habeas petition, because they would have been apprehended in that location when the habeas was filed. So if you theoretically did that, so sort of in the same way one would have a will that was ready, God forbid, if they died, if a Venezuelan decided, look, I'm a Venezuelan, so I am theoretically subject, no matter how nice of a person I am, to being apprehended as a gang member and being deported to El Salvador, I'm going to preemptively have this complaint ready and have a lawyer on call so that my family can file this right now in New York or Maryland or California or wherever. Then theoretically that court would have jurisdiction. But if you don't file the habeas until you get to your location, which is the location the government wants you to file your habeas in, then that's where you're going to be stuck filing your habeas. So that's one aspect in terms of who has jurisdiction. The jurisdiction is the place you're at the time the case is filed. That's where the jurisdiction lies. So that's the first part of this. The second part of this is that Justice Sotomayor actually said something which I don't recall any other Supreme Court justice saying, but they may have. But I just noticed it in her dissent, talking about forum shopping by the government and that some judges were more disposed to these claims than others. And that's usually something very taboo that the courts don't want to admit actually exists. But here she sort of blatantly says that there's this forum shopping and these judges that are more favorable than others, which is sort of a thing courts shouldn't want to do because it sort of delegitimizes the court writ large. But she goes ahead and says it, which I also found interesting in her dissent.
Coming up next, what about the Venezuelans already imprisoned in El Salvador? This is Bloomberg. I've been talking to immigration law expert Leon Fresco of Holland Knight about a sharply divided Supreme Court allowing President Trump to resume deporting alleged Venezuelan gang members under an 18th century wartime law. It seems like the Chief Justice and Justice Barrett are sort of switching sides in some of these emergency Trump applications. Barrett sided with the liberals in this case. The chief sided with the liberals over not withholding money for teacher training programs. With the liberals always being in dissent, do you see any reason why the sort of middle of the court justices ended up where they did in these cases?
I think it's not a line in that case. There's a line in a different case, which is the Fourth Circuit review, Judge Wilkinson. It's a really powerful line where he talks about there's two different concerns here, and he calls them both legitimate, which is one, people are very concerned. They now believe that this government is inclined to detain and deport individuals without any opportunity for error correction of any kind, and that is a very scary proposition no matter who is involved. And then the second is that the courts themselves, because of this fear, may be forced to take such extraordinary actions that the courts are also overstepping very long-held norms of constitutional law. And so the question is, who's right and who's wrong in these situations? And that's why you have these middle-of-the-road justices caught betwixt and between, because they are rightfully concerned about what precedent are we setting if we say there's no role for courts in a world where the government chooses to literally detain any individual and say there's no due process if we make a mistake here. So, okay, this person was a U.S. citizen, but now they're in El Salvador. There's nothing we can do about it. Is that really something that the courts want to enshrine as a decision? But at the same token, it becomes very complicated if the courts are then forced to issue injunctions saying you have to force El Salvador to bring back even this U.S. citizen. Because the point is courts don't do that. Courts don't force foreign countries to have these injunctions that they have to listen to. And so this is quite the very difficult conundrum of constitutional law. And I get why the middle-of-the-road justices are feeling that they are in a very stressful, tense time at the moment.
The court didn't address the fact that you have hundreds of people who have already been sent to El Salvador without notice, without a hearing. What happens to them?
That is going to be part of this other case that's working its way up through the Supreme Court. There was one individual within this cohort of people that was deported into El Salvador who was actually not a Venezuelan under the Alien Enemies Act, but was from El Salvador itself. And this individual was detained despite an order saying they couldn't be deported specifically to El Salvador. And in that case, it was a district court judge in Maryland who held that the United States government has to try to bring this individual back to the United States. Then the Fourth Circuit, in a 2-1 decision, or 3-0, but 2-1 with a concurrence, said that they agreed that the United States government has to bring this person back from El Salvador, although the one concurrent judge said they can't require El Salvador to do it. They basically have to use their best efforts if they can do it. And that case is now up at the Supreme Court, where that decision has been administratively stayed until later this week, where there is going to be a decision that's going to be made as to whether that decision will be allowed to go into effect, and the United States government will have to use its best efforts to bring this individual back from El Salvador, or whether it is true that once a mistake gets made like this, the United States has no jurisdiction and no ability to do anything about it. And so that's going to be a very interesting decision that will then come back to this other case that we've been discussing about the Venezuelans who have already been sent to El Salvador as well. Because that's going to be the question: can a court actually order the United States to, quote unquote, either order El Salvador to give them the people back, or maybe this arrangement already contemplated that, meaning they don't have to order El Salvador to do anything. Whatever the case may be, that's going to be decided as part of this other case.
You worked in immigration litigation in the government. It seems to me inconceivable that the Trump administration can't ask the president of El Salvador to send the man who was incorrectly sent there back to the United States. I mean, the president of El Salvador is coming to the White House for a visit next week.
Let's talk about this in multiple contexts. So first of all, in terms of just other cases, forgetting about this context in a second, in a case where someone is deported to another country and that person is just walking around that other country, so let's say it's Mexico or Chile or South Korea or wherever, the Supreme Court has already said in a case called Nken, N-K-E-N, that if the government is wrong, it can actually and must do what it takes to bring that person back, give them, let's say, a parole, paperwork, a flight, whatever is needed to bring this person back into the United States and to bring this person back to whatever status was the status that they had when the case was moving forward. So that was that situation. Now, this context in El Salvador is a little bit more complicated because here the person is in detention in a Salvadoran prison. And so now the question that the courts are trying to grapple with is, whose custody are these people under? And so the Trump administration is saying they are in the custody of El Salvador. They're in an El Salvadoran prison, end of story. We can no longer order El Salvador to do this. But the real question then becomes, is that true or not? Because why would El Salvador want to hold anybody in these prisons? They're doing it at the request of the United States government, and the United States government is paying them to do this. So does this not confer the power to bring this person back to the U.S. government in this situation? And that's really the issue that the Supreme Court is going to have to grapple with once the administrative stay is lifted, is really whose custody are these people in? And what makes it super complicated in the case of the Salvadoran person as opposed to the Venezuelan person is that this is an actual Salvadoran person in a Salvadoran prison as opposed to a Venezuelan person. Because at least with the Venezuelan people, it's a little bit more clear-cut that why in the world would El Salvador want to hold Venezuelans in an El Salvador prison? That belies any sort of explanation. It would have to be because they're being asked to do so by the United States government. But in this El Salvador case, it becomes more complicated. You know, maybe El Salvador has some interest in having this person in their detention facility. And so what can the court actually order there in that situation?
It just seems to me if you strip away all the legalities, some of which seem concocted to me, and look at it practically, does anyone doubt that El Salvador's president would comply with a request by Trump to send the man back? It tells the president.
It seems to me that if this entire framework was implemented at the request of the United States, that a release could occur at the request of the United States. That seems to me to be a logical proposition. But the question is, what does the law do vis-a-vis suspension of disbelief? Does the law say, no, we're going to look at the actual facts here and say that really at the end, the only reason any of this is happening is because the U.S. is asking El Salvador to do it. And so, yes, they continue to maintain jurisdiction. Or does the law create this suspension of disbelief where it says, look, we can't get into all of that. In the end, this person is now in Salvador in custody, end of story. What can we do? And so I don't know where they're going to go with this, but practically it seems to me, I don't know what the reason would be for El Salvador to say no to the United States in a particular case. I don't know. We would have to wait and see.
A lot to wait and see about. Thanks so much, Leon. That's Leon Fresco, a partner at Holland Knight. Coming up next on the Bloomberg Law Show, Trump's war on big law exposes the vulnerabilities of Wall Street law firms. I'm June Grasso, and you're listening to Bloomberg. President Trump's war on big law sees firms caving in, sometimes before the executive order against them is even issued. Milbank Tweed is the latest firm to settle in exchange for $100 million in pro bono work. So what kind of firms have the incentive to settle and avoid a legal battle with the president, and what firms would rather fight it out? Joining me is Bloomberg Law reporter Justin Henry. Justin, how would you describe the firms that are settling?
So the firms that we're seeing settle are primarily concentrated in New York. I think all of them are headquartered or at least originating from New York and have real Wall Street pedigree. They're also much more wealthy, and a lot of that wealth has come from their rainmaker transactional practices, so corporate deals involving mergers and acquisitions and private equity.
So what would be the reason why those firms would want to settle more, the ones that do transactional work?
So my understanding is that they have really sensitive client relationships, clients who are very averse to being in kind of the political limelight. Some of those firms have client relationships that are worth $100 million a year in revenue or more, and those are client relationships that could vanish literally overnight if their lawyers can't represent them in front of government agencies or get the same kind of attention from regulatory agencies to put the deals through. And then that, literally within a matter of days, could decrease the overall profitability of the firm, which would have a cascading effect on other partners of the firm, making less in profits and then also being vulnerable to poaching by other firms. So you could have a phenomenon that resembles the kind of run on the bank.
So they're even afraid that their partners will abandon them.
Exactly, yeah, and not for any individual lawyer's sort of decision-making on the process. It's really a coordination issue where, they might want to stay with the firm. The clients might want to stay with the firm, but just because of business reasons, not because of political reasons, there's no shortage of other firms looking to scoop up that business. And they can come to them and say, hey, listen, we're not in the negative limelight of the president. Come to us. Or we still have a good relationship with the administration, or at least we're not in the crosshairs of the Trump administration.
Right. And with these transactional firms that have to deal with the regulatory agencies, it could be a problem if they're in the bad graces of the Trump administration.
Yeah, exactly. I mean, a protracted dispute with the Trump administration, which 3 of the firms that have been targeted are currently in, can make them seem like kind of a pariah, politically speaking. That makes clients look at them and say, well, we're worried about not getting good treatment from the regulatory agencies that have to approve our massive bet-the-company deals. Those very expensive, very lucrative deals require the goodwill of the executive branch agencies, and that is something that is at risk when you're in a protracted dispute with the Trump administration.
I thought it was interesting. You spoke to Bruce McEwen, who was a former in-house lawyer at Morgan Stanley, and he said, law firms, for all their seeming solidity, are very fragile economically.
So law firms really aren't organized like any other type of business, except for other professional services businesses like accounting. What makes law firms different is that their shareholders are internal to the company, and those shareholders, who are the partners, have the ability to go to any firm they want at the drop of a hat. There are no non-compete agreements in the legal field like there are in other professions, so the law firm can't impose any restrictions on one of their lawyers moving to another firm, a competitor firm that's willing to pay them more. And so that's a huge reason why law firms are much more a precarious type of business than other types of businesses.
The three firms that sued Trump, what are they best known for? Obviously, they're not transactional.
Yeah, so these are firms that are, very famous for their work in the areas of litigation. And litigation is just a practice area that, is still very sensitive to politics, but already kind of has an adversarial stance by definition. Just a breed of lawyers who are much more willing to take an adversarial stance, whether it's with the government or whether it's with another private sector party. And according to the lawyers I've talked to, that kind of has bred a willingness in these firms to, in their case, take an adversarial stance against the Trump administration. Now, that doesn't mean it doesn't come with any risk. There are risks involved. However, when you're litigating in a courthouse as opposed to seeking merger clearance in an executive branch agency, the courthouses are not subject to the Trump administration's executive orders like the executive branch agencies are.
I didn't realize this. The litigation firms have less revenue than the transactional firms?
Yes, they're on average about half as much in revenue every year on average than the more transactional focused firms. And that really just goes to show you how much private equity and M&A has turbocharged the profits of the wealthiest firms right now. But I think what we're seeing right now is that it also shows you how precarious that wealth is.
You say that the same pattern applies to firms that have been publicly speaking out against the Trump administration. How many firms have been publicly speaking out?
So the number of firms that have been speaking out against the Trump administration recently skyrocketed, actually because of an amicus brief in the lawsuit that Perkins Coie filed against the Trump administration. However, only 8 of the firms that signed on to that brief are in the AmLaw 100. So when I say that the firms that are speaking out against the Trump administration are litigation firms, I mean the other big law firms. So that would be Williams & Connolly, which is representing Perkins Coie and its lawsuit against the Trump administration. And then Munger, Tolles & Olson is primarily a litigation firm that organized the brief in the Perkins Coie lawsuit. And so those are kind of the high-profile examples of firms that are willing to oppose the Trump administration and how they are pretty hard-nosed litigation-focused firms.
Trump has only targeted the big firms so far.
Yes, because it seems what he's looking for, at least in part, is hundreds of millions of dollars in pro bono legal services. Now, the bigger firms, the wealthier firms, have more resources to devote to pro bono legal services. And so that's why I think it makes sense that Trump is going after those larger firms who, I believe at this point, have committed more than $300 million in pro bono legal services to causes that Trump is advocating for.
Do we know what kind of things he's going to ask them to do?
So just to make it totally clear, what the firms have said that have pledged pro bono legal services is that they aren't letting the Trump administration call the shots down to the individual client relationships. They've just set out categories that they need to provide pro bono legal services in order to comply with the agreement. And those categories include advocating on behalf of veterans' rights. That's a very established conservative legal cause. There's combating anti-Semitism, and then there's quote-unquote fairness in the justice system. There's still a lot of unanswered questions about how they will comply with that. I struggle to imagine that the law firms and the Trump administration have the same definition of those things, especially with something as broad as fairness in the justice system. But these are clearly areas that, Trump for a while now has felt like big law isn't as fair to conservatives as it is to liberal causes. And so this is his way of, in his mind, evening the playing field.
Are these executive orders against law firms going to continue?
So I think at this point, what I've heard is that there are several law firms that have come to the table with the Trump administration in order to negotiate their way out of an executive order. When you just look at the rationale, the pretext backing these executive orders, it's hard to imagine a law firm, a high-profile law firm that Trump might not have a beef with. Everybody has some connection to a potential enemy of the president. And so that makes the potential targets of these executive orders pretty far and wide, and that, I think, is making a lot of law firms come to the table and try to negotiate preemptively their way out of an executive order.
I think Skadden did that, right? Before they had an executive order against them, they settled.
So far, we've seen Skadden do that, Wilkie and Milbank, and it's been reported, including by Bloomberg Law, that Kirkland & Ellis is in preemptive negotiations. And as late as this morning, there's been reporting by the New York Times that suggests that Cadwalader is in a similar position. And Cadwalader is notable because they are the former firm of Todd Blanche, who's in the Justice Department, obviously, and who had to leave the firm in order to represent Trump in the Stormy Daniels case.
Has anyone in the Trump administration expressed what the legal basis for these executive orders are? I mean, it seems so clearly retribution.
It does, but that what people are calling retribution has been couched by the Trump administration in the language of protecting national security interests, the language that was used in the Perkins-Coie executive order. The other legal pretext that's being cited is anti-discrimination laws. Those are being used in going after firms for alleged DEI, quote-unquote, discrimination.
That is a big theme of the Trump administration so far. Thanks so much, Justin. That's Bloomberg Law reporter Justin Henry. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.